Hi, my name is Kyusung Lee, a lawyer in Korea and head attorney of Osung Partners Law Firm. Having practiced as a Korean attorney representing foreign investors in Korea and providing legal services for the overseas clients, I have performed legal advisory for many cases where the issues associated with dismissal of employee in Korea are involved. So here in my YouTube channel, I intend to share with you the basic idea and things worth to note regarding dismissal of employee in Korea. In general, Korea's labor market is considered relatively rigid compared to other countries. It may turn out difficult to dismiss employee from company. Employers may run into legal problems such as facing Labor Relations Commission presentation case or civil or criminal suit. The term dismissal means termination of labor relations against the worker's will. To dismiss an employee in Korea, there must be a justifiable reason. Employers should not take a punitive measure such as dismissal, suspension, transfer, or pay cut against employee without a justifiable reason. Justifiable causes may include, but not limited to, the followings. First, dismissal as part of punishment. Termination due to a reason attributable to the worker can be possible. However, there must be a reason that can meet the criteria of being unable to maintain labor relations under the generally accepted social norms. Then, what's this criteria of judgment? According to the Korean court case precedents, judgment will be made in overall consideration of relevant factors such as purpose of punishment, nature of business, relevant worker's job, worker's wrongdoing, impact on the way the business is operated. But determining whether it meets the criteria is usually tricky. An employer may run into wrong conclusion without a guide or help from experienced expert. Second, dismissal due to a management reason. Dismissing of some workers under certain conditions due to management, for instance, needs of cut down in order to keep business going, is possible. In this case, there needs to be such pressing circumstances to the business and efforts to avoid dismissal as much as possible. The Labor Standard Acts in Korea are provided as below. Article 23, restriction on dismissal, and etc. An employer shall not, without justifiable cause, dismiss, lay off, suspend, or transfer an employee, reduce his or her wages, or take other punitive measures, hereinafter referred to as unfair dismissal, against him or her. An employer shall not dismiss an employee during a period of suspension of work for medical treatment of an occupational injury or disease and within 30 days immediately thereafter, and any woman before and after childbirth shall not be dismissed during a period of suspension of work as prescribed by this act and for 30 days immediately thereafter, provided that this shall not apply where the employer has paid a lump sum compensation as provided for under Article 84 or where the employer may not continue to conduct his or her business. Article 24, restrictions on dismissal for managerial reasons. Where an employer intends to dismiss an employee for managerial reasons, there must be an urgent managerial necessity. In this case, it shall be deemed that there is an urgent managerial necessity for the transfer, merger, or acquisition of the business in order to prevent managerial deterioration. In case of paragraph 1, an employer shall make every effort to avoid dismissal and shall establish and follow reasonable and fair criteria for the selection of those persons subject to dismissal. In this case, there shall be no discrimination on the basis of gender. Where there is an organized trade union that represents more than half of the employees at the business or workplace, the employer shall inform at least 50 days before the intended date of dismissal and consult in good faith with the trade union. Where there is no such organized trade union, this shall refer to a person who represents more than half of the employees, hereinafter referred to as labor representative. Regarding the methods for avoiding dismissals, the criteria for dismissal under paragraph 2. When an employer intends to dismiss personnel under paragraph 1 above, the fixed limit prescribed by presidential decree, he or she shall report to the Minister of Employment and Labor as determined by presidential decree. When an employer dismisses employees in accordance with the conditions prescribed in paragraphs 1 through 3, it shall be deemed a dismissal with proper cause under Article 23(1). Dismissal itself can become a very tricky issue in Korea. There are legitimate procedures which employer must comply with, which topic I will cover in my later videos. All in all, facing this tricky issue, I would recommend consulting with experts and acquire proper legal assistance. If you have any further questions, please use the reply function of this video. Thanks for watching.